All right, I think we're going to go ahead and start. Thank you everyone for joining today. Today we're going to do a deep dive into CMBS loans from a hotel borrower's perspective. We know that defaults are imminent and owners have questions and concerns about what lies ahead. So today we're going to focus on 1, strategies to negotiate with servicers, 2, understanding the legal landscape for borrowers, and 3, what might systemic relief look like? We're also hoping that this type of information will help the servicer and the bond community, along with policymakers, understand the real pain points for hotel CMBS borrowers. Now today we're nearly at max capacity for this webinar. It tells us how important this subject is. I know that we have expected about an hour for this webinar. It might go a little bit longer based on the amount of questions we are expecting. We did ask the panelists today to stay longer and they have all agreed to do so. So with that said, the conversation today will assume 2 facts. First, that all the loans that we'll be talking about are in good standing or have been in good standing up until the point of the impacts of COVID-19 impaired travel and employment. 2, most of us are expecting some type of government intervention. However, for today's purpose, we're going to assume that that intervention likely will not happen before May 1st. And if and when it does, it won't explicitly define the actual reliefs that are needed for hotel CMBS borrowers. Additional part to this, most hotel borrowers are at different points in a process. Some that are in or have completed negotiations with their special servicers, and many that have reached out to their masters or special servicers and are about to start negotiations. So with that, let's get started. Quick disclaimer, today's webinar is for informational purposes only and should not be construed as legal advice. You should contact your counsel with respect to any particular issue or problem you may be having with your specific CMBS loan. So let's talk about the problem. Next slide, please. So I feel like the last 3 or 4 weeks have felt like years. And it's easy to, it's easy to forget that today is only April 10th. We're literally 9 days removed from the April 1st payment that most of us just made. According to TREP, roughly 3,000 CMBS loans totaling over $86 billion are backed by hotel properties across the United States. Over the last so many years, about 15% of all CMBS loan pools are accounted for by hotels. Those loans, about 2,500 of those 3,000 are loans that are single property hotel CMBS loans. The balance are portfolio hotel CMBS loans. And as of last week, about 3,000 of the 3,000 loans, 476 loans are on the watch list and 97 are marked as delinquent. And that data is not even yet reflective of March's results. What makes hotels as a different category and asset for servicers to consider is one, that we are smaller in size compared to some of the larger office or industrial buildings that might sit on our loan pool. We're definitely smaller. Second, we do have daily leases versus monthly and annual leases. And obviously we can tell in our industry right now that the minute the travel bans had occurred, our occupancies dropped the very next day. For the most part, we usually do not have tenants. We are both the owner and the operator of our hotels and also the employers of our people. Right now, servicers are asking us to work on some projections We, I think, all understand that projections are very difficult to make during the COVID-19 shelter in place. It's hard enough to see what might happen in a week, let alone what might happen in 6 months or 9 months. These, we understand, could be really challenging for servicers to help understand how to make a decision with us. But one point I think is very, very critical we want to highlight. Hotel CMBS borrowers have little to no experience with special servicers. For many, they've never had a missed payment or a default, and many haven't had a CMBS loan prior to 10 years ago. And there is a reputation that hotel borrowers have heard about of the servicers. So hotel CMBS borrowers have a significant lack of trust, and many are expecting the worst. Now, we don't know if policymakers and bondholders truly understand that we as CMBS borrowers, we have fears. We have already heard about debt funds being formed to take out our hotels. Some we hear may even have plans to shut the hotels down and not keep anyone employed until the economy recovers. These employees, for many of us, are family. They become friends. We are their livelihood. We know that this is a highly unregulated industry, and it's very different than the traditional bank loans that we're accustomed to. One owner had come to me recently and said, Girish, I liken this situation to an animal farm. Owners are like the animals that are sick. They all got sick around the same time. And they're all being ushered into the medical building. But most of the animals also know that that medical building might be the slaughterhouse. So we don't know exactly what will happen when we go through this. We're just all hoping to come out the other side with the least amount of damage as possible. Next slide. So as of today, what we're going to go over, we're going to focus around a result of a survey that we recently put out, just to help understand for everyone out there what our borrowers actually look like. We want to talk about what these discussions with servicers will be like. What are some of the lessons and pitfalls that we want to implement based on conversations that have already been occurring? We also want to understand our legal considerations through this process, as well as what could be on the other side of this process. And then lastly, we'll also talk about systemic relief, and that'll lead us to a Q&A portion. Next slide. So my name is Girish Patel. I'll be your moderator today. I'm principal and co-founder of NewGen Worldwide. And part of my responsibility is to oversee the assets that we own. We, like many of you, are actually hotel owners, and we do have hotels financed through CMBS. With us today, we have experts that have spent their careers working on behalf of borrowers when dealing with troubled CMBS loans. First, we have Tonya Little. Tonya Little is the founder and CEO of Hart Advisors Group, LLC, which is a real estate advisory company based in Dallas, Texas. Since Hart's inception in 2009, Tanya and her team have completed more than $5 billion of commercial loan restructures, assumptions, and recapitalizations. Drawing on over 2 decades of experience in real estate finance, Tanya has built Hart Advisors as a proven business platform focused on distressed real estate. You will see at the bottom, Tanya has experience with all of the major servicers that include Midland, Wells Fargo, Brocadia, Citus, Rialto, Eleanor, C3, Torchlight, CW Capital, Prudential, and Principal Group. Additionally, today we have Brian Mahany. Brian's an attorney with over 35 years of experience. His practice focuses on lender liability claims on behalf of borrowers and fraud claims on behalf of the United States. In 2014, Brian was one of the lead plaintiff counsel in a record $16.65 billion settlement against Bank of America. At that time, the largest civil recovery against a single defendant in the history of the United States. As well, Brian has significant experience with servicers, including Wells Fargo, L&R, CW, Rialto, and Oryx. And lastly, we have we have Chris Caters. Chris is also an attorney with over 13 years experience. And his practice focuses largely on representing borrowers in both litigation and pre-litigation who are experiencing difficulty with their lender. That experience includes both CMBS and non-CMBS loans. Chris has a background in finance, and that allows him to approach each client situation from not only a legal standpoint, but a financial standpoint as well. Chris has experience with the following servicers: L&R, Rialto, Midland, CWC, Hudson's America, and Wells Fargo. We'll be asking Tanya, Brian, and Chris a series of questions today that have already been populated by concerned owners. At the end, we'll begin a Q&A portion based on questions coming in from owners during this webinar. We asked the attendees today to click on the question button at the bottom of your screen, and you will be able to enter questions that you may have. And at the end, we'll read those questions back to you. So Tanya, if you don't mind, at this point, I'd like for you to introduce yourself and tell us a little bit more about you and your company.
Great, thanks so much. Again, Tonya Little, we have a great team of professionals here in Dallas that basically grew up in the lending world and have worked for master servicers, special servicers, and lenders in general. So we started right after the Great Recession and have done workouts for the past 11 years, working with borrowers specifically on CMBS loan transactions for the most part. So we're really well-versed, if you will, in the process of CMBS, how loans go through master servicing and then special servicing, and setting our expectations for clients so that they understand what to expect if they go through this process and exactly what that means to them, their loan, and ultimately their property.
Thank you, Tanya.
You're welcome.
Brian, how about yourself? Brian?
Muted, apparently. Oh, I'm unmuted now. Thank you. Yes, I'm Brian Mahany. I have been a practicing lawyer for over 30 years now. I work with Chris Caters, the other panelist, the other lawyer panelist with us today. And we are one of the few law firms that work exclusively for borrowers. In other words, we don't represent banks or special servicers, and we have extensive experience in the hospitality industry, and in particular, working with borrowers that have CMBS loans. So we've worked with most of the major servicers between Chris and I, and we're looking forward to your questions today and sharing some wisdom.
Thank you, Ryan. And lastly, Chris, please introduce yourself. Chris?
Yes. Oh, okay. Now it's unmuted. Yeah, just to add to what Brian said, I mean, most of our, well, all of our lender work is together. We don't represent lenders. We consistently represent borrowers inside the CMBS world and outside, but the majority of it is the CMBS world. Most of my practice is civil litigation, both on behalf of borrowers who are defending themselves against lenders, and to some extent, borrowers who, after they're outside of a loan and have moved on, want to take action against the lenders for their conduct before. So our familiarity is, we have some familiarity, well, quite a bit with the process up front of modifying the loan, but a lot of what we do is also on the back end, once these loans end up in special servicing and once litigation starts, how to handle that. And, we understand the process of the foreclosure process of how the trust ultimately gets that loan out of the trust, often selling it to a related party. And we've been able to successfully, at times, buy that loan out of the back end. So much of my experiences with the actual litigation and after defaults have been declared and we end up in litigation, but we've certainly handled it prior to litigation as well.
Thank you, Chris. Well, so let's move along here. So our next slide, please. And what you'll see here is a result of a survey that we recently did at NewGen Advisory. And that survey is, north of 150 respondents now, but we went ahead and took our first 100 respondents for the sake of our presentation today. So who are we? What do our borrowers actually look like? I think we know, we believe the servicers know, but let's look at us as a whole. So with those first 100 responders, those responders represent over 200 CMBS loans. About half of those are over $7 million and 25% are over $10 million. Now we will tell you that over the last couple of days, as more results have come in, these are very reflective of most of the United States, and they're scattered through multiple states. And you will also notice a trend that's similar to all CMBS pools, where there are some that are more dense in areas like maybe Florida or California, more scattered maybe in states such as Texas. But I found very reflective of what we think the actual audience looks like. What you'll also notice, and I think this is really important, that we as hotel owners and borrowers, we are the large employers of the service industry. 70% in a normal day have over 20 employees, and most of them will be full-time equivalent employees. Next slide. So here, let's talk about the actual performance of our business right now. So as you can see, almost everyone is still open for business. We've probably, depending on where you live, have had a travel restriction for 2 weeks, maybe 4 weeks. But for the most part, hotels are staying open, and the ones that are not may either have had a positive case in their hotel that has made it difficult for staff to be retained, as some people have told us, or that it just became so difficult to operate the hotel still that it made more sense to close. Well, the big shocking element for me was when I saw this next one, when we talked about our occupancy. As you can see, there's only about 10% of these hotels that are all open running over 20% occupancy. Tanya, I wanted to throw a question at you.
Sure.
Do you think the servicers and bondholders know that our situation is this dire?
I think that they do. Now, how they react to that is probably not necessarily as swift as one might think. Partially because they have limited resources. Remember, we were in recovery mode until this event happened as well. So each of the special servicers, I know for sure, really only have 1 to 2 resources that were dedicated to hotels. So I think everyone's aware and they are hearing from borrowers of how dire the situation is. However, they have very, very limited resources right now to process this information that's coming in.
Can we go to the next slide, Mike? So here we're looking at our payments. This we find very, very interesting. And I think, folks, this tells us that we are officially at the inflection point. We have flipped between where we were a few weeks ago to where we end up being here the next few weeks. about a third of us did not make the payment in April, and less than a third of us are going to be able to make the payment here in May. And I think that is the premise for where we sit today. We are in that middle. Chris, let me ask you a question. What can we learn anything from those that missed that 4/1 payment? Are we considering it's only April 10th? Have we had enough time to understand the results or the pain that comes from that missed payment? Chris?
Yes. Sorry, I'm having a muting issue. I mean, from what I've seen to this point, I haven't seen anyone actually receive a default notice. But I think the pain that comes along with that is immediately there is no longer any sort of defense to that from a litigation standpoint. The special servicers now have, you know, for lack of a better term, they just simply have a leg up in regard to those that haven't paid. Putting aside all the equitable and legal arguments that could be made, now there's a default, and often when you get into court, that's all a judge would look at. So for those that haven't paid, and I understand most of those decisions were simply financial decisions or the inability to pay, it kind of forms a situation. But yes, I would think, without knowing, I would believe the special servicers are probably putting those loans that haven't been paid in a different tranche than those loans they suspect haven't been paid. And if they systematically look at them differently, the ones that haven't been paid on 4/1 are probably being looked at closer and being analyzed. Though I agree with what Tanya said, they don't have a lot of resources, but if they are looking at certain loans, I'm guessing they're paying more attention to the loans that weren't paid on 4/1 as opposed to the loans that were paid.
Maybe I can provide just a hair more of the kind of layman's, if you will, what's happening to your loan if you didn't make your 4/1 payment, just as far as within the master servicer. It is likely that your loan will not be transferred to special servicing until you've missed 2 payments or 60 days. So you may just be in kind of a holding pattern, because they really won't transfer the loans until a period of 2 missed payments or 60 days. So if you think that your loan might have been transferred, it's possible that it hasn't. A lot of the requests that are going in right now are going in and being reviewed by the special servicer, but that does not mean it has been transferred yet to the special servicer.
Yeah, they have what's generally called a watch list. And from my experience, yeah, once you end up on that, it kind of sits in limbo, where it's still in special servicing, but the master servicer starts having input or becoming, it's still in with the master servicer, but the special servicer starts having input and knowledge of the loan.
So how might that shape our borrowers that are sitting here today that made the 4/1 payment but might not be able to make the 5/1 payment? Many fear that their world will become very difficult maybe a week after May 1st. Chris?
Yeah, from my perspective, I mean, those that can't pay or don't pay on May 1st, you know, it's going to give them additional time. I think as Tanya is explaining, that won't necessarily push them into the special servicing arena. They may still stay with that master servicer until, you know, the June 1st payment or sometime around them. But it's going to be heightened with inside the master servicer and the special servicer. It's probably going to end up on what's routinely called a watch list. And depending on the resources of the special servicer and how much time they're putting in, they're going to start looking at those particular loans. And from my experience, the longer you can avoid the special servicer even looking at your loan is typically better. Outside of this situation, often when special servicers get involved, it becomes much, much more difficult. So I think those that are looking at the May 1st payment, and I don't mean to skip ahead, but one of the questions was, you know, should it be made? from my perspective as a lawyer, you're always in a much better position if you make your payment. But that those that don't pay, they're going to be probably treated how those that didn't pay in April are. They're going to end up on a watch list, and they can still communicate with their master servicer. But now we have a special servicer involved, which on some level typically would be bad. But here, if we're requesting relief, some sort of forbearance or short-term modification, the special servicer typically has to approve that anyway. So there could be advantages and disadvantages to that, but typically speaking, if I were advising someone, I would try to stay as far away from the special servicer as I could. But again, if I'm looking to access the special servicer, it may not be the worst thing in the world that I'm on that list. But once you're on that list, unless you get a modification or you cure what was the alleged default, getting off that list is not always easy.
Can we move forward 2 slides, please? So as we're looking at our negotiation process, and I'm sure as you guys are talking to your clients, these are some of the factors that you're going to be considering. So as we look at this, we have 2 areas right now that are very different for many. One is on the reserves. So you'll notice here that a third have less than $100,000 of reserves, and almost a quarter of responders have over $500,000 in reserves. Tanya, let me ask you a question. Depending on where you're at in this spectrum, does it impact your strategy when you're negotiating with servicers?
Well, now may be a good time to talk about what can be done today, okay? That whether you've made your April payment, whether or not you're planning to make or can make your May payment, let's talk about what can be done. Right now, each special servicer is kind of putting together their plan, but we're starting to see what the results of those and what can be done. So this is not, I'm going to tell you, each special servicer is different and likely to have a different process and a different fee structure associated with that. There is short-term relief available by you using your reserves, and that's in the form of a consent. So what that means is no modification to the terms of the loan documents. You can use your FF&E reserves for the most part for debt service payments, and you can also postpone potentially your FF&E reserves for a period of 90 days. This is likely not to get you transferred to the special servicer, but the consent itself is granted from the special servicer. So for those of you that have reserves out there, those consents can be requested. And I will say this, and I'm sure Brian and Chris would agree with me. The terms and conditions around the pooling and servicing agreements and other guidelines that govern CMBS loans, it's very, very important how you address these loans as to not be put in special servicing. When you are suggesting that there could be or is or will be an imminent default, that can move you into special servicing with really little or no suggestion as to what that means. So it is very careful, but the use of your reserves, if you have them, can be done on a consent basis. It looks like we're seeing some yeses on that from Midland and Wells and a few of the larger ones. So if that's requested appropriately, you should be able to use that for some of your debt service relief. And we'll talk in a minute about what longer term relief looks like, or if you don't have any reserves.
Thank you, Tom. And Brian, I'd like to look at the lockbox arrangement. Kind of going back to the previous question, depending on what where you're at in the stage of potential default. Many that we've spoken to are very fearful of a hard lockbox kicking in and how that will impact, conducting their operations with even more limited access to funds when the situation is difficult enough as it is. When would you foresee the servicers trying to trigger hard lockbox arrangements if we're only at missing their first payment or potentially approaching missing their second payment right now?
That's an excellent question. I think we'll see servicers begin to trip hard lockbox requirements after the second payment is missed, particularly those borrowers who in good faith contact their special servicer and say, hey, I'm broke, I'm in default, I can't stay open any longer. Any of those magic words can accelerate that typical 2-month period and land you directly into special servicing. Tanya mentioned that a minute ago, and it's an important, it's something important to emphasize. Be very careful in what you say, because saying I can't pay anymore or any of those words that affect can land you there very quickly.
And we will be talking about some of these pitfalls and lessons to be careful as we go down this road. Let's shift a little bit to our next slide. So this actually, I guess I found out interesting. The more and more we have spoken with some of our clients and friends, actually, you'll start noticing there's a repeat of names. And this might be a good time to actually just, take this thing back a couple of steps and help people in the audience that may not know where they're at to look at explaining the actual roles and the parties involved in the servicer process in the CMBS loan process. Tanya, would you like to take a crack at that first?
Yeah, I'm going to do it real simply and say your master servicer is who you make your payments to. They can handle draw requests and simple loan process payments, and that's really what their role is. Special servicers are there, for lack of a better term, when your loan is in trouble, when you're in any type of default situation, bankruptcy situation, something like that. That's where they're going to get transferred. Your loan gets transferred basically from your master servicer to your special servicer, because the special servicer really is the one that's going to handle the more complicated issues of the loan. Very high.
No, it's good. There's a lot of pieces in this puzzle, right? Brian, could you talk a little bit on the other side of the servicer? So when your master servicer gets the payment from you at the end of the month, and they are then usually remitting that money over to a trustee, and then it goes to bondholders. Can you explain to some of our audience about those other parties involved in the CMBS process?
Sure. So many of the borrowers that we speak with, particularly those in the hospitality industry, have never dealt with a CMBS loan before. And I think that's borne out with your slide to your survey, have just one property or one CMBS loan. So in the traditional bank situation, you have a banker, you have somebody that you can talk to. In the CMBS world, there is no, the note holder is a legal fiction. There's no office, there's no building, there's no staff. That it's owned by a trust, and the trust speaks through its servicers. And the master servicer, as Tanya explained, typically gets paid a flat fee, and they look at your required financials, they collect your monthly payment, they make sure the taxes are paid, they make sure that the property is insured, and they conduct an annual inspection or whatever is required. It's much more difficult when you have a CMBS loan to find somebody that can make any changes. A bank can modify a loan, the master servicer cannot. And that's why I said before, you have to be very careful when you contact the master servicer. Typically, it's the special servicer that has to make any, approve any modifications, and what you say, it's like those TV shows, can and will be used against you. And special servicers are typically only paid when the loan is in special servicing. So unfortunately, special servicers have a financial incentive to see you stay in special servicing for a longer period of time than, let's say, a bank would. It's a much different model, and you have to understand that when you're getting ready to approach a servicer.
Well, thank you for that, Brian. Chris, when we look at this survey, and you see, when you look at special servicers, right? Midland, 19%, Rialto, 21, Eleanor, 15. That is over 50%. And I think when we see 24% Wells Fargo, we probably just assume that that's a lot of that's a lot of borrowers that may actually just not know who their special servicer is. And so it's fair to say that that will actually be probably broken down into those other three as well. So why are, when every hotel is going through a similar situation with such little time left, and there's only 3, 4, 5 servicers that we really need to deal with, why are we being asked to go at this one by one? Chris?
Yes. Well, I think it's the model that we've been talking about. The special servicers have always behaved that way. And I think they are probably strategically right now sitting back and coming up within their own, Eleanor and Rialto, how they're going to approach each individual borrower. But I think that's their traditional model, is to have in each individual borrower deal with them directly. Now, the ones I have talked to, and I haven't talked directly to an asset manager at a special servicer. I've talked to lawyers who they forwarded me to. And the response I'm getting from the lawyers is, well, we still have to go through our, what the contractual documents say, and we have to, follow the legal procedure. And this is pure speculation, but I think that gives them an advantage. I think they want to play some of this out and push it back. They're not like a typical bank, as Brian was saying. They're not backed by the FDIC. The special servicers here don't have to basically explain their actions to anyone. At the end of the day, theoretically, they have to explain them to the trust. But these loans, they're not turning around to the FDIC or the OCC and explaining why loans are in default. They don't have to have backup for them. So I think that's part of the reason they're doing it individually. And I think some of these they're going to look at and say, in fact, we're dealing with some where they're going to ask for information, and some of them they want to dig through. Most of these are pretty. Most people don't even know about their special servicer, because if you make your payments and you submit your financials on a regular basis, you're going to stay with the master servicer and never deal with the special servicer. Now, typically, when you get to the special servicers, when they'll start asking questions, they'll start looking at your financials, they'll start asking questions about your financials. So that's their typical process, and they deal with people individually. And I think that's why here, I think they're also trying to buy some time to see how they are going to strategically deal with each person. But I think certain borrowers that are in a better position and were operating well before are going to be dealt with one way by the special servicers. But other operators that were maybe right on the fringe before, the special servicers may look at those loans differently and pull them out. Because again, as Brian said, the special servicers get paid when loans are in special servicing. So I think they have some incentive, as opposed to sit back and say, look, we're going to give everyone a 90-day forbearance. They have an incentive to stop and say, okay, let's look at this particular loan and this particular loan. And they often when they run the default interest, well, let me take a step back. When you see a 3-4 months down the line, if someone says, look, I missed some payments, I want to come current, they'll do what's called a bring current statement. And on there, you'll see special servicing fees and you'll see default interest that the special servicers get to collect. So they have a perverse incentive to kind of deal with people individually. And that's their typical approach to these things. And truthfully, they may not have a lot of guidance from their technical client to trust about how the trust wants them to handle it.
I understand that. And recently we just got approached by the Real Estate Finance Council, and there were a few other members, including Eleanor and Wells Fargo, that were they were trying to convey to us that there is a bit of a challenge, even though they have some manpower, there is a challenge trying to understand how they want to handle all this. So we can appreciate that. Next slide, please. So here you can clearly tell right now, there are a lot of owners that have reached out in some capacity. Some have just made a correspondence, and some have actually gotten as far as submitting some type of a request or relief. Tanya, simple question at this point. If someone hasn't actually formally submitted a request or supplied the documentation that's being asked from that part, is it reasonable to assume they can get an agreement or a forbearance executed before May 1st?
It's reasonable to make the request. Again, it's all going to be a resource issue, probably more than anything. We are having good luck speaking with the asset managers directly on the special servicing side, but that might be because we were speaking to them before this event happened. But I do think that communication is important with the servicers, them understanding where you are. I think the biggest problem is they're flooded with requests and multiple asks. And it has always been an environment of basically make your request, and if it hits the sweet spot, you're going to get answers the fastest, and you're going to get approvals the fast. So if I have clients that we engaged last week that went in and the first ask they made was, oh, I need 9 months of forbearance. Well, there's really issues around that for the trusts, and they're not really able, number one, to offer that. That's not a good solution for them. And I understand that it's the hotels that are hurting and the owners that are hurting, but they're also weighing their bondholders and their investors. And if it's almost got to be in that sweet spot to really kind of get a positive response back, which is why I wanted to talk about what your first thing you can do today is with the reserves. I think overall, I agree with you that each servicer is still formulating what they are going to do based on what the requests are. And it also goes through a process. There is a very, very succinct process as to master servicer, special servicer, who gives consents if it's not in the format that it needs to be in. It's kind of like that SBA application that you put in likely. That process exists in master and special servicing too. So all of those things are considerations when you say, are you likely to get a response back before May 1? The other thing I just wanted to say too, just so everyone's aware, most of these CMBS loans do not allow for additional debt, and that could include the government PPP loans or the SBA loans. And if you are making a request and you are out there and you've applied for these loans, even if you don't know if you've got them yet, that is something you're likely going to need approval for from your special servicer.
Well, thank you, Tanya. Actually, that goes right into my next slide.
Oh, good.
Yeah. So you'll notice we asked everyone where they were in terms of filing for those loan applications a week ago. And you'll notice here we have only 19% has not applied for one of these loans. And there clearly you'll see both the EIDL and the PP loan that have been applied for. So let's move into the next slide and let's see how this shakes out. Okay, so well, one of the things we know about the PPP program, there is a element of forgiveness. Hypothetically, someone that has a traditional $40,000 or $50,000 payroll can get a little excess of 100,000. But with the labor situation being what it is, and the formula of factoring FTEs and things of that nature, there's a likelihood that we will not be utilizing all of the forgiveness opportunity, that maybe the amount of money that owners take versus what will ultimately get forgiven, there will be a delta. And so between that, for that PPP element, Brian and Tanya both, do you foresee that that consents will occur now, but they will not become issues later when there is still an element that is not forgiven?
I mean, I'm asking for the consents now, whether or not we have approval or not. Many of these PPPs have not even been approved. I don't know of a lot that I've heard of that have been approved. So I'm putting it out there for our clients, regardless of whether or not they're approved or not, forgiven or not, and we're going to wait and see what that feedback is.
Yeah,
Brian,
it's a tough question, because if you ask, you run the risk that the special servicer says no. To the extent that we've gotten any feedback thus far, it's been, we'll think about it, or just quiet, nothing, no response. No one has said yes, and no one has said no, at least in our experience. I think you're a little bit safer with the Paycheck Protection Program, the PPP, because at least it's arguable that some of it is, or all of it is forgivable. The economic injury disaster loan is a loan. And I think that special servicers very well may say no, but at the same time, if you have to keep your doors open, we suspected in your slide, or your survey just told me what I had anticipated anyway, that most people are just going to go ahead and do it and ask for forgiveness later.
Yeah, we are being told by some of these borrowers that they've applied, they expect they'll take it, but as they're talking to servicers now, probably maybe because they don't have representation with them, the servicers are asking if they have applied and for copies of those applications. So Chris, what would you suggest to those individuals when they're being asked this question from their servicers?
Well, it's honestly kind of a Hobson's choice. I mean, to the extent that you don't provide them, and they find out about it later, maybe give them a larger incentive to take action because of that. I recently had a situation where they're going after a personal guarantee from someone on a springing guarantee who lent money from his own. He had several entities, and he used money from another entity to pay a CMBS loan, and then paid that entity back, and they're going after him for taking additional loans. So, the idea of not disclosing it to them obviously carries a ton of risk. But if you do disclose it to them, they certainly could take the position that, well, if you take this money, you're in violation of the loan, and because you're in violation of the loan, we're not going to grant you any relief. I haven't seen their response yet. And again, in typical times, they would use anything they could to not grant you relief. So I think we always have to advise clients to be honest to the extent that don't hide things, because I think that could hurt them later. So I would provide them the information. I would ask for the consent that Tanya's asking about. And ultimately, if they say, well, if you take this money, we won't consent to it, at least you know where you are. If you take the money and you kind of don't disclose it to them, that's certainly a potential issue in the future that 2, 3, 4, 5 years down the line, they could use against you.
So let's move really quickly to the next slide. And we're not going to spend a lot of time on this. This is very recent, and I think some borrowers, we want to look into this. It's called the Main Street New Loan Facility. And if you haven't heard about it, I'm sure a lot more press is going to be coming forward. It is an unsecured loan. It is a much larger loan. There is a fee that comes with it. But maybe the attractive part is that you are eligible up to 4 times the borrower's EBITDA. And this might be not necessarily for the borrowing entity of a CMBS note, but maybe an affiliate. So we just wanted to slip that in so some of you can actually go and investigate that later on, okay? Mike, let's move on. So now let's talk about the lessons here happening that are on the front line. What's actually getting approved? What's not getting approved? How should the negotiation actually work? So let's first, before we get to that actual, the numbers, the dollars and the cents, next slide. Let's get into some of these pitfalls and lessons that Brian and Chris have just been talking about. So we want to make sure we avoid mistakes. Chris, on the legal side, talk about the P&A and the forbearance agreements, and then I'll ask Tanya to comment about the fees that she's seeing.
The pre-negotiation agreements, as I imagine many people on the phone may have seen already, they're very common, not only in the CMBS industry, but lenders in general use them. It asks you to waive a substantial amount of rights, generally asks you to admit you're a default. Outside of what's the perceived reason for it is that the conversations are confidential. They will sneak often waivers of liability, like I said, acknowledgement of default, that this is how much you owe. And oftentimes these are simply used to just get people to concede those. I can tell you a lot of times they refuse to negotiate with you if you don't sign them. So typically there has to be some pushback and ask for certain provisions to be taken out. And at the end of the day, there just has to be, at a minimum, an educated decision about what you're actually signing. People get understood in this time period. People are looking for relief, so they sign these things and don't understand what they're signing. Forbearance agreements are very similar. They often will give you the relief you're looking for, either short-term debt service payments, but again, they ask for an acknowledgement of default. They'll ask for a waiver of liability. Oftentimes what CMBS lenders will do is they'll waive default interest, and that may not be an acute issue right now because it's not accumulating for everyone, but they'll ask you to waive, or they'll waive default interest, charges, special servicer fees, etc. But they don't actually waive them. They'll move them to the back end of the loan. And another thing you have to be careful for is they'll simply defer them, and they'll say, but if you go into default later, we're bringing those all back into the equation. So I've had several clients who have entered into a forbearance agreement, paid their loan for the next 3 or 4 years, and then they go to pay off the loan, and they didn't have legal representation when they signed that forbearance agreement, and they come to figure out, well, the payoff was $10 million, but this LNR or Rialto is saying, well, no, it's actually $12 million. Go back and read the forbearance agreement. So people have to be very, very careful what they sign. Those forbearance agreements are drafted by the CMBS lender, by their lawyers, and candidly, they're not fair agreements. They're to be fair. They're written to give every advantage to the lender if anything else goes wrong, or at times if they just feel like being difficult at the end of the loan. So it's very important to have those agreements, I think, reviewed. And like I said, at times, it may be the only choice you have, and the lender may not change their position, though they do at times. But everyone at least has to understand what they're signing and the pitfalls of walking through going forward. Because people often sign them without understanding what's there, and as they move forward and operate their business, they don't actually know they're breaching that forbearance agreement because they don't understand everything that's they actually agreed to.
And Brian, thank you for that, Chris. Brian, the additional collateral guarantees, we know that's been something that's been thrown around depending on some of the negotiations. Tell us about how far you could probably go, Brian, before guarantees are probably necessary. And how often do servicers end up actually going after the guarantees?
Typically, they use the guarantees as a bargaining chip, but it's a very real danger. I mean, many people went the CMBS route initially because they thought that these were non-recourse loans. By non-recourse meaning, hey, if worst happens and everything falls apart, I can walk away and I'm not on the hook. And so a business savvy special servicer will figure out, okay, so you have a non-recourse loan, but if you want us to enter into a forbearance agreement and defer payments for 6 months, we want something in return. We want a guarantee. I should also mention that you have to be careful of what are called Badboy Provisions, or other people call them springing guarantees, and you may have those in your loan documents already. In other words, your loan says it's a non-recourse loan, but if you do certain things, you could trigger a guarantee. And one of those things is, for example, just closing your doors. So you really should get some help either from an advisor or a lawyer before signing anything. And if for no other reason, as Chris mentioned, just to make sure you understand what you're doing. Thus far, I have not seen a special servicer actually collect on the guarantee, but it certainly gives them far more leverage over you.
And
Make
this
our
is,
bargaining position much weaker.
and this is Chris. Over the last week, I actually have seen them at least write a letter demanding it. In one of the large pitfalls of even the current guarantees people sign, they're supposed to be limited guarantees, but some of them have springing provisions that if the special purpose entity does something, you're liable. And some of them actually say one of the things that can spring liability is the special purpose entity is not properly capitalized. So they try to sneak those things in where they refer back to the loan agreement, and they'll list a whole series of things that the special purpose entity can't do. And some of them are things, as like I said, as blatant as not keeping the company capitalized. So it's essentially saying, if you don't have enough money to pay your debt, we can spring these guarantees. So they certainly try to sneak as much as they can into those guarantees. And as Brian said, 99% of the time, they use them as leverage to negotiate, or if they do attempt to foreclose, to say, look, you're liable for all of our attorney's fees. So if you fight us, we're going to come after you for those. But I have seen in limited situations, and it was a confrontational situation with L&R where before we were involved, it was not a good relationship or a respectful relationship. But after the fact, they're at least taking the position they are going to pursue guarantees.
And Tanya, talk to us about fees. There seems to be a lot of misunderstanding about what fees are traditional and what they might look like in today's environment with some type of forbearance.
Yeah.
I'm sorry, was that for Tanya or for me?
Oh, sorry, Tanya.
I'm happy for you to jump into and what you're
Absolutely.
on the low end. We're usually seeing, if you want to do the consents, we're looking at them wanting you to put up some sort of legal retainer. I don't think the consents for the most part that I'm seeing are really negotiable, but they ask you to put up usually at least, this is minimum, a $5,000 legal retainer. And then the consent fees, the lowest I've seen are $5,000, but I'm also hearing $10,000 and more from some of the other special servicers. And that's where I go back to, each special servicer is different, and they're likely to potentially require different fees.
I guess Brian, Chris, do you concur with those numbers?
Yeah, this is Chris. Oh, go ahead, Brian.
From the 100,000 foot level, remember that when you're dealing with a traditional lender, which is not the folks on the phone today, but that's most of our experience in life, there's a relationship there and a value to that relationship. When you're dealing with a special servicer, the special servicer only gets paid while you're in default or while you're under their thumb, so that they are quite creative in the types of fees and default interest and review fees. They can be very, very creative. They're somewhat negotiable, but that's how they're getting paid.
Let's move to the next slide, please.
And the other thing we might just talk about, special servicing fees can get very, very costly. There are multiple levels of fees that they can charge, and there's also just your default interest, late fees that are part of your loan, but then there's also workout fees, modification fees, special servicing fees. There are a lot. So to go into special servicing, it's really important that you understand and that's, you know, what's likely to happen. And also, you know, kind of what that means to you if you're to come out with a modification that's successful.
And just to add to that real quickly, and they'll add their own legal fees, which are some of the most expensive firms in the country. So the more when you're in special servicing and you're negotiating a modification, a forbearance, a workout, and they're willing to do it, that whole time you're paying their attorneys. And when they get that final number, I mean, the bills are oftentimes in the six figures, depending on how long the negotiations are. But that's another large hammer that they'll tell you, and you have to pay our attorney's fees. And all of a sudden you'll get to basically the table to close it. And they'll be like, oh, they're $89,000. So for what that's worth.
Well, let's take this, I think, to the next level. Knowing all of these things and looking back from our survey, everyone starts understanding their own factors, and hopefully a lot of these borrowers are working with professionals and advisors such as yourself. Now you've got to go in and make an ask. Forbearance periods, what to do with the reserve, suspension of covenants. We didn't talk much about that, but getting consent to use these relief programs, consideration fees. What are you seeing happening? I think this is where the brass tacks is. The first, call it the animals that have come through. How do they look coming out? What do we learn from them? What is getting approved as an overall? Are there things that are 180 days? Are they getting approved? Tanya, can you tell us what you're seeing?
Yeah, I mean, remember, we're only a few weeks into this, and they're still processing on their side too. There's a lot of information that needs to be submitted when you make these requests. Remember, forbearance is not a waiver. Number one is what I would say about that period. For the most part right now, 90 days is the staple. That's what we're seeing. Use of reserves can happen. Suspension of financial covenants can happen. Not events of default or bankruptcy, but debt coverage ratios and LTV can happen. And the use of the government programs, I'm just talking high level over all of them, will require some type of consent as well.
And Brian, are you seeing anything else in terms of a longer term strategy? Many have wondered in this approach, should they go and ask for something long term and expect a response back potentially where they can get something more long term?
Well, I mean, it's an excellent question. We're still having problems getting feedback. Most of the initial questions have been over use of the government relief programs of the EIDL funds and the PPP funds and use of reserves, but people should be looking more long-term. I'm afraid that some people may be asking for just 60 days or 90 days because politically we hear people say we're going to get back to work in May, and I think for our industry it's going to take a while before people start traveling. So notwithstanding what the politicians may say, I think we should be asking for more. But again, we're so new in this game right now. It's hard to tell what kind of long-term help we'll get from the government, if any, and what the special services are going to say if you come in and say, hey, I need a 6 months of relief or longer.
And so Tanya, how does that inform you when when some of your borrowers are coming in and saying, you know, hey, the economists are already predicting it's going to be deep into 2021 before we see a significant recovery. You know, something short-term is only a Band-Aid. How does this inform your approach? Are you going in with 2 levels of offers? Are you throwing in the long one and then seeing what response occurs? Tell us how you're handling that.
I think we're doing exactly what we see that the special servicers will do. We have worked with them for a long time now, and so we're looking at every single one of these assets on a one-by-one basis, if you will, and talking to our owners about what that asset, after we've reviewed it, we re-underwrite our loans as well. And talking to them about, okay, what does the long-term impact look like versus a short-term impact? We are doing some longer-term modifications. We actually have rolled out a program that's really kind of a relief modification, and we're trying to streamline that into the special servicers. But we do believe that if there's a long-term needed, then we need to address it. But there's so many considerations for each one of these individual borrowers that you almost do have to look at it on a case-by-case basis. And so that's what we're still continuing to do.
So if we want predictability for today, what should our offer be that we can expect a high likelihood of approval?
I think it's exactly what I mentioned earlier, and that is the use of your FF&E reserves. That is something that is basically their way of saying it's a way for us to still get paid on the loan, but yet you don't have to necessarily today worry about making those payments. I think that that's a realistic it may not cover all your problems, but it's the reality of what can be done today. If you don't fit into that box, then you're going to need a longer term approach. And that's really on an individual asset and individual owner basis.
So let's shift to the next slide. So let's talk about these servicers and how their reputation I think is informing us and maybe additionally of what to expect. So clearly we want to be able to trust the communication that we're making with our servicers without fear. Brian, tell us about these servicers. Help us understand them better. How are they different? How are they same?
Well, that's a great question. And I think that's what all 3 of us have been trying to do throughout this whole presentation. The servicers are not a traditional bank. They have no regulatory oversight. As hard as that is to believe, the FDIC, the Office of the Comptroller of the Currency, the individual states, the Federal Reserve, no one regulates these folks. They are not in a long-term relationship with you. They don't have the traditional help thus far anyway that the government has been offering banks. So for example, the FDIC has relaxed regulations for banks that if the bank gives you at least 90 days and perhaps up to 60 days on a traditional loan, the bank doesn't have to record that on its books as a troubled asset, doesn't have to reserve against it. The servicers don't get that help. So they don't have help from the federal government. They don't have oversight from the government, and they are very, very, very tough to deal with. Another piece of the puzzle is banks have rules against owning foreclosed real estate. Believe it or not, special servicers don't. It would be in the pooling and servicing agreement, which is a 600 to 1,000 page document in that creates each of these trusts, but they can not only bring a foreclosure action if they choose to on behalf of the trust, they can actually acquire the property for their own portfolio. And I think when you start to put all of those pieces of the puzzle together, you realize that the way you would approach a bank is much different than the way you would approach the special servicer that's controlling your loan.
Yeah, no, I think we, as we're coming to learn, you start removing some of the layers of the onions. There's some things there that don't look so pretty, and all the right reasons to be concerned. So let's move on into legal considerations. Clearly, we know assuming that we've got an agreement, we'll sign into a modification. We've understood some of the pitfalls. Let's look at it if things are not working out. And Chris, I want to turn this to you. If things are going in the wrong direction, foreclosures are a concern, or drastic actions are a concern stemming from some of these default activities. What do you do? What should an owner do? What should they be thinking about here?
Well, yeah, approaching it from a litigation side, it's a unique time, and these guys are used to going into court and getting their way. There is a way to defeat them, and they have been defeated. But you want to start, that's the balance here, is you want to try to get them to work with you, but at the same time, you want to sort of set up potential defenses you could have. Typically you don't have a defense of the world outside is causing this problem, but there is an impossibility doctrine, which is coming to life again right now, where you end up in court. And the reason you're in default here is, at least the argument is at this point, it's not because the economy shut down, it's because the government actually ordered everybody to stay home. Therefore, the government actually issued orders that make running your business or your business running profitable basically impossible. So from that perspective, you want to start setting up their certain defenses. And along with that, I know many people on the phone are probably very committed to keeping their properties. Some of those little legal considerations are how you fight that as well and try to get them to the table. They're extremely well funded. Generally, they will just fight and fight and fight. And if you get into litigation, you have to have an end game. I see a lot of people, most of our clients end up hiring us 3 or 4 months after they're in the litigation. And it's not because their other attorneys aren't good attorneys. They just haven't dealt with this particular area. And many of them think they're dealing with a traditional bank, and then they realize they're not. So strategically, if you get to that point, or you are committed to going down that road, there has to be a takeout plan at some point. Most of the time when these things end up in litigation, they end up either in L&R's hands if they commit to foreclosure, or another special servicer's hands, or a group they're associated with. So there's many strategies to get them to the table to either allow you to refinance the note at an amount lower than what they're asking for, or to actually purchase the note from them at a discounted value. But what I do see is a lot of people just go into the litigation with this strategy that, well, the lender wronged me. And that may be true, but ultimately what's your end game? Because even if they did, interest is still running, you still have to pay back the note. And I think that, along with the considerations of everybody walking or understanding what their guarantee obligations are, because my guess would be 95% of the people listening, when they signed guarantees, believed that those were pretty limited guarantees and they didn't cover much. So you go back and read those along with the other 400 or 500 pages of loan documents. Some of them do have loopholes in there. So I think people need to be real secure in what they're risking before they go down that road. This goes back to not only the guarantees, but to the extent that people are loaning their own businesses money of their other cash. Now, I think an owner could make a capital contribution, but I think people have to be real careful with, if I own entity A, it is a CMBS loan, and I own entity B, which is cash flowing and fine, taking money from entity B and giving it to entity A in a lot of situations is springing guarantees for people. So I think some of those are the 10,000 foot level legal considerations. And I'm always kind of a point of I'm posturing for litigation. But that's kind of how I see it. you don't want to be confrontational necessarily when you're trying to get them to work with you. But you also have to set up what would be a defense later. And that goes back to, on some level, people making the May 1st payment. As a lawyer, I can't, and I never have advised the client not to make a payment. Because when you can go into court and tell a judge, well, I never missed a payment, and they put me into default for some technical reason for, occupancy or debt service ratio, or my reserves weren't properly funded, that along with the environment right now is going to go a lot further with a judge if you can say I made my payments. But I think from the 10,000 foot level, those are the things people should be considering. And again, I know we talked about it earlier, but any documents that are signed should be thoroughly examined by an attorney, because they will sneak many things in there that refer to, a different document over here. It says this, and they're very sophisticated counsel who's very good at putting things in that basically tie up the borrowers, to the extent that if the borrowers don't do everything to the T going forward, it then gives the servicer, either the special servicer, generally the special servicer, the ability to kind of pull the plug whenever they want to. And I've seen that happen to many people who sign forbearance agreements in good faith, and 2 or 3 years later, the lender turns around and says, well, you didn't do this and this right, and these people are operating, they're paying their notes. Now, again, that's in typical times. I'm hoping they'll behave better here, but that all remains to be seen.
So Brian, so I think, look, you made one very important point. People want to keep their hotels. So, hoping while they're working through the strategy and being concerned about what could happen on the back end and understanding some of the legal options they have, let's look at systemic relief. Right now, there is something that is being discussed. It's about the TALF. Let me turn this to you, Brian, real fast. Explain this program and what you think that does for the hotel owner.
Well, the TALF has been around. TALF stands for Term Asset Backed Securities Loan Facilities. It's been around for a long period of time, and because recently some of the folks in the CRE folks have been pushing this, and it's gotten some publicity now, and people think it's the panacea or the cure-all for our problems. I think in the short term, it doesn't do anything for us. In the long term, it very well may. TALF allows banks gives banks an incentive to put money or liquidity into the CMBS markets, because it allows a bank to keep a loan on their balance sheet and pledge it to the Federal Reserve and get money for it. It's available now for multi-unit family housing that are done through CMBS loans through Freddie Mac or Fannie Mae. It isn't available for us yet. And if tomorrow, there was just a proposal yesterday. That's how fast all of this is changing. But it's still not going to change anything for us overnight. Down the road, it may help us with refinancing, and in fact, probably will. But if you're facing a default right now because you can't make that May 1st payment, I don't think TALF is going to help. I've been scrolling through the questions and answers, and several people have asked about it, which proves my point that people out there think it's a cure-all. And we have remedies and things we can do right now. I don't think TALF is one that's going to help in the short term.
Well, then, look, with that, I think let's go ahead and open ourselves up to the questions. I know we've gone a little long as expected. I think there's a lot of substance that a lot of people wanted to understand because so many people are at different stages with a lot of thoughts. So,
and I've been trying to answer a lot of them just on my own.
I've been a little bit too kind of.
Do we have any on the queue right now that we want to go ahead and bring out here publicly?
Some are a little bit more complicated than others to just answer, I think, but those that we could answer, I know I've answered about 20 of them so far.
I'm looking
Tanya,
at
this is Kyle Walker here. I've been synthesizing a lot of these questions that some of our participants are asking, and one seems to be common. I've seen this asked about a half a dozen times. So if I'm a hotel owner and I have the ability to pay off my CMBS loan, you guys have all scared me sufficiently. I do not want my CMBS loan anymore. I want to go back to the traditional bank lending. How would I go about that negotiation? Is there opportunity for discounted payoff? Can you talk to us a little bit about what that would look like if I want to pay my note off?
Yes. Okay. Well, number one, when you think about paying your CMBS loan off, all of these loans have a defeasance clause in them. And that means that they have basically guaranteed the interest payments on these bonds for a certain period of time. So if you pay off your loan early, then you may be subject to defeasance depending how early that is. And you would need to do the defeasance calculation. There's a website called Defease with Ease. Just gave them some props, but they have a little defeasance calculator that you can enter your information in, and you can see what your defeasance on your loan might be. So you would need to consider that in paying off your loan. So whatever your principal and interest might be today, you would have to add that defeasance on to pay it off in full. As far as discounted payoffs, that's really a product of valuation. So if your note is $5 million and your hotel's worth $6 million, it's not likely that they're going to let you just take that loan and pay it off unless it covers defeasance and the principal balance of the note.
Yeah, that's where they revert back to their alleged duty to represent the bondholders. And that comes from the bondholders essentially bought the bonds for the right to the cash flow from the interest payments. And if they're not going to receive those interest payments, the trust doesn't have the ability to go invest your payoff of the loan into another asset that's going to provide a return. So on that one, at least Tanya may have a different experience, but trying to get that prepayment penalty, if you will, waived, I've seen it reduced. We've got it reduced slightly, but oftentimes they dig their heels in on that one, and yeah, especially if there's equity in the property. So they fall back on, well, we have a duty to the bondholders who are entitled to this much money. I'm not saying it's not worth asking, but I haven't typically seen them back off those.
Where it really comes into play that it could be waived is if the value of the hotel is not there. And that's where you've got a little more leverage to talk about waiving defeasance. But again, that's probably going to go into special servicing, and they're going to determine if they believe that the value you say it is what they think it is.
And there's a whole, the special servicers, to the extent they're not like typical banks, there is actually provisions in that 700-page, well, like Brian said, 600 to 1,000-page document of what they can and can't do. Right. So it's not like walking into your local bank where they can say, look, yeah, pay us the principal, give us another $500,000, we'll walk away. They have to actually follow their own procedures as how they do that. So they don't have ultimate discretion just to waive those things either.
Okay. All right. Next question we've been getting a lot is, I've been reaching out to my master servicer and nobody's been responding. I'm trying to engage. I'm trying to get more information or consent for a PPP loan. What do I do if I'm not getting a response from my servicer?
I mean, I can tell you in the last 2 weeks, when I, as a lawyer, have requested as opposed to clients, I generally get a response, but I'm getting it from I'm not getting it from the asset manager. I'm getting it from lawyers. With L&R, it's typically Dwayne Morris in San Francisco. But to be candid, there's not a heck of a lot you can do except asking someone, either an advisor or a lawyer to try to push that to a higher level. In my experience, special servicers and servicers for that matter, but more special servicers ignoring borrowers for lengthy amounts of times and not responding to their requests is not uncommon.
And I would say, as a consultant, we do speak directly to the asset managers. And I think at this point, while response times have been slow for a very, very long time, I would say a lot of that is likely due to the load that is coming in right now. And these people are working remotely as well. And so you have to understand they're in the exact same position most of us are, as far as their ability to respond and limited ability at this point.
So Tanya, earlier in the presentation, you spoke about these special servicers having limited resources. What did you mean by that? Is this a limited headcount, limited, what is creating that limitation, and how quickly might they be addressing something like that?
Yeah, I mean, this is no different than the Great Recession, right? They special servicers really weren't planning for this event either. And being in a recovery, they weren't staffed really to handle that amount of loans. Most of the loans, what we call CMBS 1.0, has been paid off, and therefore as those loans dwindled, their staff dwindled. So you're just not looking at very large amounts of people that are in special servicing, because there just wasn't the need. And now there's going to be a need to have people to process these requests.
Makes sense. One of the other questions we're getting, obviously people are a bit concerned around these pre-negotiation letters. And one of our participants asked, is it possible to get consent to use reserve funds for P&I payments without first signing off to a pre-negotiation letter?
Typically, the servicers are not going to talk to you without signing a pre-negotiation agreement. And their rationale for that is they want to assure that settlement negotiations remain private and can't be used in court. That's all well and good, but we all know that many of the special servicers are inserting all kinds of other language in the P&A. I think when I say P&A, the pre-negotiation agreement, I think you probably have to sign it in order to talk to them, but I think you can negotiate some of the terms, particular terms that say, I'm admitting a default before we even negotiate anything. I'm rolling over and saying I'm in default. A pre-negotiation agreement should not be a forbearance agreement. They're completely separate. And I think you have a right to say, hey, time out. We're not going to put this language in here. Again, if you run into problems, you may have to hire an attorney or consult with your attorney.
So the other place there's been a lot of conversation is around the fees associated with a special servicer engaging. Can you engage in negotiations related to those fees? Do you guys have any guidance on kind of rough estimates of what's reasonable and maybe what's not reasonable? But it seems many of our participants are reacting to the size of these fees, and also the feeling that the work is relatively uniform across all hotel borrowers. So how could they possibly be charging me this much and charging maybe me that much on each of my CMBS loans that is a dozen plus? And so how can we start to realize some efficiencies in fees? Is that possible in the negotiation?
This is Chris. I mean, I've seen the CMBS lenders act like many lenders in general, that they kind of make it up as they go, to a great extent. I mean, I've certainly seen them back off those numbers. If that's the one thing holding up a deal that's actually good for their clients, I've seen them back off them. But I don't know that the argument that, well, you just did this really wasn't any work, is necessarily going to resound with them. I mean, it may, but I don't think there's any real calculation on their part or any real consideration. Now, in this situation, there may be. I mean, they may say, we're going to do all these and we're going to charge $10,000 per consent, or if we do a forbearance or a modification. But in my experience, that number it just seems to come out of thin air. It is a number that it's one of the first numbers they seem willing to at times just drop. But I've never understood the basis for coming up that number. And I don't candidly think there is one besides what someone decides it is.
Talking real quick around shutting down a hotel. Occupancy is so low, the property is hemorrhaging cash. And we've got participants who really feel shutting down the property is the best business decision, but they're concerned about making a CMBS loan all of a sudden a recourse loan. Tanya, any advice there on how to potentially navigate that? Is shutting down an option if communicating in the right way with your servicer?
I mean, yes, it's an option, but again, it would need to be communicated with the servicer. Obviously, some income versus no income is a big deal for them. So, and as I think Chris or Brian mentioned earlier, it could potentially get you into a recourse trigger. And that's really important that, that you stay away from those types of bad boy clauses. So you want to make sure that you speak to your attorney or counsel about that and how best to go about that if you feel like that's the best thing for the asset.
And this is a tough one, guys, and I don't know if any of you will be able to answer it, but it's something that many have asked. We've talked about the SBA relief that's out there. Obviously, there are some complications in CMBS borrowers taking that on. We've talked a little bit about the Federal Reserve and what they're doing with TALF and how that creates liquidity to the market. Do you guys know of, or can you articulate any mechanics that may be potential for legislative relief that would make its way down to a CMBS borrower? I think many of our participants have political connections. They're looking to engage and make an ask, but how would federal legislative action provide relief to a hotel CMBS borrower?
This is Chris, and I'll give this is the 10,000 foot level. Without going through the specifics, my understanding is one of the reasons, besides diversifying risk and being able to get these loans out the door and all the other things they do, there's significant tax advantages. And if you go through that pooling and servicing agreement, and even sometimes the loan agreement, things are structured a certain way. And it's my understanding is so there is tax advantages to the bondholders that are holding the bonds and the way those taxes pass through. So you don't have the OCC or the FDIC, but I think the way the IRS code is written and federal legislation in that regard could be a way for the federal government to legislate something that essentially these trusts would have to comply with, or they could lose certain tax advantages. That's kind of my 10,000 foot understanding of basically the oversight, the only oversight the government really has or control that they currently have over how they do business.
All right, guys, I think, look, I'm sure there are more questions in the queue. I would suggest we allow for more questions to keep coming through, but for this portion of the webinar today, we're going to go ahead and conclude. So right now, I want to thank all the panelists for coming. I'm hopeful that they were extremely informative. I think they were, and that can help you guys determine your strategy and hopefully overcome some of your concerns. On your screen, you're going to see their contact information, and we will be sending this webinar as well as the recording, as well as some additional information that the panelists have given us. We're going to send that to everyone that's registered today. So thank you all again. And we wish you all a safe time and hopefully you guys all have a good weekend and a good Friday. Thank you. Take care. Bye.
Thank you.
Thank you.
Thank you.